Good morning. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is May 22nd, 2019. The time is 9:30 a.m. With us today are Commissioner Emily Lindley and our General Counsel, Mary Smith. I'm John Neerman, and I'll ask Ms. Smith to call the first item.
The first item is old business item number 1, the consideration of the ALJ's proposal for decision and proposed order concerning the denial of the applications of James Trimble for a new on-site sewage facility site evaluator license and renewal of his on-site sewage facility installer and maintenance provider licenses. The order of presentation will begin with the executive director, followed by the applicant, Mr. Trimble, and then OPIC. By letter dated April 5th, 2019, the parties were notified that they will each have 5 minutes of oral argument time, and the executive director may save time for rebuttal as he bears the burden of proof on the denial of applications. And so the executive director's staff is here to present the item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Alicia Ramirez, and with me is Haya Zeman, PE, Director of the Permitting and Registration Support Division. We represent the Executive Director in this matter. The ED agrees with the Administrative Law Judge's proposal for decision and proposed order and recommends that the Commission adopt them. We are available for any questions.
Thank you. I have none. Commissioner Lindley?
I don't have any questions, thank you.
Mr. Trimble, are you here if you'd like to approach? And I think the first thing, sir, is just make sure that the light is turned on in that microphone so we can hear you. There should be a button that says push.
Yeah.
Sounds like we got it. And then just state your name for the
James
record.
Trimble.
Thank you. And then you can go ahead, and I'd ask you to confine your comments to matters that are on the record that were presented at SOA, because that's really all we can consider at this point.
Sure.
Thank you.
On our last meeting, I asked for attorney representation.
Yes, sir.
Since then, I've been in contact with the law office of Ross and Matthews. They're my prepaid shield legal provider.
Mm-hmm.
They sent me 2 people. Neither one of them do this type of law. But I have what they sent me. I'm still looking for an attorney for counsel.
Well, Mr. Trimble, we're really not in a position without a compelling reason to continue this further.
There's a strong, compelling reason, sir, honored sir. I have rights to have an attorney, I believe, and I have been trying. This is proof.
Sir, I think we've given you a reasonable amount of time to hire counsel.
I have the proof that I've tried, and they didn't send me to anybody that could help me. They're a reputable law firm, Ross and Matthews.
Well, Commissioner Lindley, what are your views?
Well, you know, obviously, you're given the chance to try, and you've tried, but I tend to agree with you, Chairman, that at this point we need to move forward with this action. You know, it's unfortunate that there was a misunderstanding between you and the law firm, but today where we are,
Would y'all at least look at the proof that I have that I've tried?
I don't know if we can.
I understand and appreciate that you've tried. We're just not in a position to continue this matter any further.
That I don't have counsel?
Yes, sir. And there is an opportunity to appeal any action that we take here. And if you feel
Yes,
that...
but I've read into the laws, and y'all's rulings are pretty much it. And it's not fair for me to have representation, sir.
Well,
My name is on here. My phone number is 936-672-1600. I just want to get some legal counsel, and I haven't been able to find it yet.
well, sir, I'm not going to debate this with you. We're not going to continue this matter. You can represent yourself here on the matter. In any event, we're going to need to move forward with this item and take some action.
I would just beg you, please, sir, let me get counsel. I've been trying to get counsel, and I haven't had a chance to get counsel yet. I want the counsel. I'll get the counsel. I just haven't had a chance.
I can't do that for you, sir.
Thank you.
Thank you, sir. OPIC.
Good morning. I'm Pranjal Mehta for the Office of Public Interest Counsel. After review of the PFD and all subsequent filings, OPIC supports the Administrative Law Judge's proposal for decision. OPIC agrees with the ALJ's recommendation that the Commission deny Mr. Trimble's application for a new on-site sewage facility site evaluator license and Mr. Trimble's applications to renew his on-site sewage facility installer and maintenance provider license. OPIC further agrees with the ALJ that for the 5 years prior to the filing of his applications, Mr. Trimble has a record of multiple continuing violations of rules adopted by the Commission under the Texas Health and Safety Code and enforced by Montgomery County. These TCEQ rules and Montgomery County Ordinance rules are intended to protect the environment and public health. OPIC agrees with the ALJ and ED that this record demonstrates a lack of competence to carry out duties required by these licenses. Therefore, OPIC supports the ALJ's PFD and recommends that the Commission deny all 3 of Mr. Trimble's applications. I'm happy to answer any questions. Thank you.
I have none. Commissioner Lindley,
No, I don't have any questions. Thank you.
Executive Director. And do you want to use your any of your remaining time?
We have no rebuttal.
Thank you. I appreciate that that these licenses are a means to a livelihood for Mr. Trimble, and so I do not take this lightly. But we need a compelling reason to do anything other than to follow the ALJ's recommendations on this matter, and I agree with the ALJ. I think it's important to acknowledge the record in this case. Mr. Trimble has approximately 75 instances of failure to submit maintenance inspection reports or contracts. He failed to obtain final inspections for 17 systems. He has 36 convictions for failure to call for inspections and submit maintenance reports. It's also important and should be noted in the findings of fact that Mr. Trimble submitted 39 maintenance inspection reports before those inspections were actually performed. And given the demonstrated lack of ability to comply with the rules that apply to this occupation, we just cannot grant these licenses. And I am sympathetic to your position, Mr. Trimble, but I think we're compelled to take this action. I don't think it's even a close case, nor do I think, for what it's worth, that council could help with this record either. Those are my thoughts. Commissioner Lindley?
I appreciate and agree with everything you said. I think you actually laid out everything very well. So I don't really have anything to add on to your comments, but I am ready to make a motion if you would.
I'm ready to hear it.
I move that we adopt the ALJ's proposed order with the following change. Add finding of fact number 12A to state, Mr. Trimble submitted a total of 39 maintenance inspection reports to the department before the inspections were actually performed. And that would be the end of my motion.
The motion has been made. I second it. All those in favor say aye.
Aye.
Aye. The motion carries. Next item.
We're moving on to the new business portion of the agenda, and so we will be taking up item new business 1, application by Tex-Mix Partners LTD for air quality standard permit number 152399. The parties have been notified that the commission will not take oral argument but may ask question. We have representatives of Tex-Mix Partners and also of protestants here with us. They've signed in and are available to answer questions. Their presence will be noted for the record.
So, Commissioner Lindley, we have several requesters on this item. Most have failed to demonstrate that they are entitled to a contested case hearing, either because they reside more than 440 yards from the facility or they failed to timely submit comments. But the following people, I believe, have shown that they are entitled to a contested case hearing, and those are Ms. Hager, Ms. Profit, Ms. Recop, and Mr. Recop. And then I thought that Kristen and William Wassail, forgive me if I'm not pronouncing that correctly, I thought that the Wassails are somewhat of a special case. They did submit timely comments, but the record is mixed on whether they in fact reside within 440 yards. So I propose that we refer the Wassails effectiveness determination to SOA, and then go ahead and grant the hearing requests for Ms. Hager, Ms. Profit, and the Recops. And if that sounds all right to you, I can
That sounds great. I would agree.
get into the issues. Okay. I think the referable issues are whether the proposed plant will cause nuisance conditions or negatively affect air quality, and whether the draft permit is protective of human health, animals, and vegetation. Does that capture your thoughts?
Yes, those two are yeah. Did you mention whether
Whether the proposed plant will cause nuisance conditions or negatively affect
okay.
air quality.
Mm-hmm. That
And-
works. I would agree.
And include an ADR referral and allow 180 days for hearing.
I would agree with that.
I'll entertain a motion.
I move that we grant the hearing requests of Diana Hager, Juanita Margot Profit, Caitlin Rakop, and Ryan Rakop. Refer the hearing requests of Kristen Wassail and William Wassail to SOA for an effectiveness determination. Deny the remaining hearing requests and all the requests for reconsideration. Refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with the SOA preliminary hearing scheduling efforts. And refer the application to SOA for a contested case hearing on the following issues: whether the proposed plant will negatively affect air quality, whether the draft permit is protective of animals, vegetation, and human health, including sensitive groups, and whether the proposed plant will cause nuisance conditions in violation of 30 TAC 101.4. Set the hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued. Does that covers what you were?
That captured it, yeah. The motion has been made. I second it. All those in favor say aye.
Aye.
Aye, the motion carries. I see raised hands back there, and I'm sorry, we're not accepting comment on this item. What was the name, please? Robert and Maria Wilshaw. That was one of the, we didn't name all of the requesters by name, but that was included in the group that we had denied the request for, if that helps clarify. We only named the parties for whom we granted the requests, and the Wassails who we are referring. So they were included in our I can't speak to
My motion.
I can't
Yes.
speak to what Commissioner Lindley saw or how she prepared for this. I'm sure she prepared well for this, but they were considered when I evaluated this item. Ma'am, in order to be granted a contested case hearing, we are looking for people who, as I mentioned in my comments, reside within 440 yards of the proposed facility and who timely submitted comments. Okay. That was not my conclusion, nor Commissioner Lindley's conclusion when we looked at this matter. And so we have effectively disagreed with your position, and so that particular hearing request is denied, and your only recourse at this point is to take our action up on appeal. Let me be a little bit more careful about that. You have recourse at the State Office of Administrative Hearings or ultimately in district court, but I'm not in a position where I can offer you legal advice. All right, next item.
Item number 2 is the application by Capital Ready Mix LLC for new source review authorization number 149092. The parties have been notified that the commissioners will not take oral argument but may ask questions.
So Commissioner Lindley, on this item, we have two requesters, Ms. Wagoner and Representative Allen. The representative's hearing request did not contain sufficient information to make a determination that she is an affected person. But Ms. Wagoner does raise relevant issues, and her property is close to the proposed facility. So I would grant her hearing request and refer the following issues: whether the draft permit is protective of air quality and human health and safety, and whether the application, air modeling, and draft permit adequately addresses buffer zones, fencing, and paving. I would not refer the water quality or water discharge issues, since those issues are not relevant and material to this application. Does that make sense?
Yes, I would agree. I had to dive a little deeper into this one, to be honest, to understand Ms. Wagoner's arguments and to, make sure I found them compelling enough. But after looking at the map, I found that very convincing. Her proximity to the property makes me agree with you that we should refer her to hearing. But I agree that the representative's comments were not appropriate to be granted hearing status. So I can make a motion. I agree on the issues as well, and I'm ready to make a motion granting Ms. Wagoner's hearing request, if that sounds good to you.
Ready to entertain the motion.
I move that we grant the hearing request of Marguerite Ann Wagoner. We deny all remaining hearing requests. We refer the matter to the Commission's Alternative Dispute Resolution Program for a period to run concurrently with the preliminary hearing scheduling process. That we refer the matter to SOA on the following issues: whether the draft permit is sufficiently protective of air quality, whether the draft permit is sufficiently protective of human health and safety, and whether the application, air modeling, and draft permit sufficiently address the necessity for buffer zones, the type and size of fencing, and the paving of roads and surfaces, and that we set the hearing duration for 180 days from the date of the preliminary hearing until the proposal for decision is issued.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries.
Item number 3 is the application by CW Construction Development LP for new Texas Pollutant Discharge Elimination System permit number WQ00155950001. The parties have been notified that the commission will not take oral argument but may ask questions, and there are representatives of CW Construction here. If the commission has questions, their presence will be noted for the record.
So Commissioner Lindley, on this item, Ronnie and Peggy Belanowski, who own property close to the proposed facility, have raised several issues. We're only allowed to refer issues that were raised during the comment period, and the Belanowskis had just one of those, and that related to nuisance. So I propose that we grant their request and refer that one issue.
I would agree, and because it's one party and one issue, I would propose that we shorten the hearing time to 120 days if you're comfortable with that.
That makes sense, and include an ADR referral.
Yes.
Yeah.
Yes.
I'll entertain a motion.
I move that we grant the hearing request of Ronnie and Peggy Belanowski, that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with the SOA preliminary hearing scheduling efforts, that we refer the matter to SOA for a contested case hearing on the following issue: whether the draft permit contains sufficient provisions to prevent nuisance odors, and set a hearing duration of 120 days from the date of the preliminary hearing until the proposal for decision is issued.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries.
Item number 4 is consideration of the petition for the dissolution of Somerset Municipal Utility District Number 3 of San Jacinto County. The petitioners who are requesting the dissolution order should present the matter, followed by other landowners in the district. Presently, I don't believe we have anybody signed in to speak. The executive director and OPIC, we recommend limiting the parties to 5 minutes for their presentations, and the petitioner may reserve time for rebuttal. And Mr. Bethke for the petitioner is here to present the item.
Good morning, Mr. Bethke. How are you?
Good morning. Doing well, thank you. How are you guys doing?
Good, thank you. Will you make sure your light is turned on there so we can,
Yes.
on the one on the microphone, I want to make sure we can hear you.
Yep, lights on.
Great. Just state your name and
Sure.
affiliation for the record.
My name is Joshua Bethke, and I'm here representing the petitioners petitioning for dissolution of Somerset Municipal Utility District Number 3 of San Jacinto County.
And you can go ahead with your
Sure.
statement.
So this district was created by the 81st Texas Legislature in 2009. The district never organized, never held any meetings, never put a board together, never held any elections. They've been financially dormant for more than 5 years. And so the majority of the landowners have gotten together and requested to dissolve the district.
Thank you. Commissioner Lindley, any questions for the petitioner?
No questions, thank you.
None here. Thank you, sir.
Thank you.
Executive Director.
Good morning, Chairman Neerman, Commissioner Lindley, General Counsel, and Public Interest Counsel. My name is Bobby Salehi, and I'm here representing I'm an attorney with the Environmental Law Division, representing the Executive Director. With me is Chris Ullman from the District Section. The Executive Director received a petition from the representatives of AP Point Blank Limited Partnership, APMI Athens Limited Partnership, and Somerset Shores LLC to dissolve Somerset Municipal Utility District Number 3 pursuant to Title 30, Texas Administrative Code, Chapter 293, and Chapter 49 of the Texas Water Code. We've reviewed the petition and concluded that all applicable requirements have been met. The Executive Director therefore recommends granting the request and dissolving the district. We're available for any questions that you may have. Thank you.
Thank you. I have none. Commissioner Lindley?
No questions?
OPIC.
OPIC agrees with the ED that the petitioner has satisfied the requirements for district dissolution set out in Texas Water Code Chapter 49 and Chapter 293 of the Commission's rules. We recommend granting the petition for dissolution of Somerset Municipal Utility District Number 3 of San Jacinto County.
I agree. I think under our rules, this dissolution is necessary and desirable, and
Agree.
the petition has met all the legal requirements, so I would move forward.
I agree. I move that we grant the petition for the dissolution of Somerset Municipal Utility District Number 3 of San Jacinto County and issue the Executive Director's proposed order.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries. Thank you, sir. Thank you.
Item number 5 is the consideration of the material changes to contracts for goods and services awarded under Chapter 2155 of the Texas Government Code, executed during the previous quarter. Good morning. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Mr. Chairman, Commissioner Lindy, General Counsel and Public Interest Counsel. For the record, my name is Nora Randall, purchaser of the Financial Administration Division. I have with me Chris Gobert, Procurements and Contracts Manager, and Allison Scott, Compliance Evaluator of the Financial Administration Division. We are representing the Executive Director. The items contain the material changes made for the contracts and purchases of goods and services between December 1st, 2008 and February 28th of 2019. The reported material changes include extension of the contract or completion of work for 6 months or more, or an increase in consideration of 10% or more. In accordance with Section 2155.088 of the Government Code, the Executive Director presents these items for your consideration. I'm available to answer any questions you may have.
I have none. Thank you,
I
Commissioner
don't have
Lindley.
any questions either. Thank you.
Mr. McWhirter.
OPIC recommends approval of the resolution acknowledging material changes to contracts for goods and services as presented by the Executive Director.
I agree. I think these changes are appropriate and think we should move forward.
I agree. With that, I will make a motion. I move that we approve issuance of the Executive Director's proposed resolution that acknowledges the material changes to contracts for goods and services in accordance with Section 2155.088 of the Texas Government Code for the period of December 1st, 2018 to February 28, 2019, as described in the TCEQ Interoffice Memorandum to the Commissioners and Executive Director dated April 9th, 2019, and docket number 2019-0461-MIS.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries. Thank you.
Item number 6 is consideration of gifts and donations of $500 or more in value given to the TCEQ submitted for approval in accordance with Chapter 575 of the Texas Government Code concerning acceptance of gifts and donations by certain state agencies. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Mr. Chairman, Commissioner Lindley, General Counsel, and Public Interest Counsel. For the record, my name is Beth West of the General Law Division, representing the Executive Director. And before you are the gifts and donations received by the agency within the last 90 days. In accordance with Chapter 575 of the Government Code, the Executive Director has accepted these gifts and respectfully requests your acknowledgement of these gifts. And of course, happy to answer questions.
Thank you. Commissioner Lindley, any questions?
No questions this time.
Mr. McWhorter?
OPIC recommends approval of the resolution acknowledging acceptance of gifts and donations as presented by the Executive Director.
I agree and think we should move forward with this.
I agree. I move that we approve issuance of the resolution that acknowledges the Executive Director's acceptance of the gifts and donations contained in the TCEQ Interoffice Memorandum to the Commissioners dated May 3rd, 2019, with the caption of docket number 2019-0462-MIS.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries. Thank you.
And that will bring us to the enforcement docket, items 7 through 32. On item 16, we have several individuals who have signed in and it indicated that they don't wish to speak unless the commission has questions. Their presence will be noted for the record.
Good morning.
And the Executive Director's staff is here to present these matters.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Janice Hernandez, and I'm the Agenda Coordinator for the Litigation Division. With me today are Charmaine Backens, also of the Litigation Division, and Brian Sinclair and Melissa Cordell of the Enforcement Division, representing the Executive Director. Pending before you are items 7 through 32. The total assessed administrative penalties are $1,116,191, with $103,480 deferred, $337,454 applied towards supplemental environmental projects, and $675,257 to the general revenue. The Executive Director respectfully requests approval of these items, and we are available to answer any questions you may have.
Thank you. Commissioner Lindley, any questions?
No, not this time.
Mr. McWhorter?
My office reviewed these items, and we recommend issuance of the proposed orders.
I agree. I think it's appropriate to move forward on these.
I agree. I move that we adopt items 7 through 32 as recommended today by the Executive Director.
The motion has been made. I second it. All those in favor say aye. Aye.
Aye.
The motion carries.
Item number 33 is the consideration of the monthly enforcement report, and the Executive Director's staff is here to present this item.
Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me is Brian Sinclair of the Enforcement Division and Charmaine Backens and Janice Hernandez of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2019 through March. There were 747 effective administrative orders issued, and of those, 89 contained supplemental environmental projects. These orders assessed a total of $6,891,862 in penalties, with a payable amount of $4,293,338. $1,498,347 are to be paid towards supplemental environmental projects. 9,937 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 932 enforcement action referrals have been received. There are 1,562 pending administrative orders with 126 cases that are on the backlog. 217 cases are pending at the Attorney General's office for representation in district court, and 12 judgments have been issued. 2,115 cases are being tracked for compliance. We have included for review a summary of OCE investigative activities for fiscal years 2017, 18, and 19. We are available to answer any questions you may have.
Thank you. I have none. Commissioner Lindley,
I don't have any questions either. Thank you.
appreciate the report. Mr. McWhorter,
Thank you for the report. I don't have any questions.
no action is necessary on this item, so thank you.
Item number 34 is consideration for adoption of the amendments to 30 Texas Administrative Code, Chapter 342, the regulation of certain aggregate production operations. And the Executive Director's staff is here to present the item.
Good morning.
Good morning, Commissioners, General Counsel, Public Interest Counsel. On behalf of the Executive Director, my name is Laurie Fleet of the Water Quality Division. With me today is Michael Parr of the Environmental Law Division. The proposed rulemaking implements changes to the Texas Water Code made by House Bill 2582 from the 85th Legislative Session. House Bill 2582 amended Texas Water Code Section 28A.001, number 1, to add a new exemption to the list of existing exemptions and the definition of aggregate production operation. The exemption applies to a site at which specialty or terrazzo-type stone is removed or extracted from the earth, the material is produced for commercial sale, and used exclusively for decorative or artistic uses, and the horizon that is exposed for current production does not exceed 5 acres. The rulemaking would amend 30 Texas Administrative Code, Chapter 342, to add the new exemption in House Bill 2582. Additional changes would replace regulated activities with extraction activities throughout the chapter and amend Section 342.25E for consistency with Texas Water Code Chapter 28A. The rulemaking would also add definitions for decorative or artistic uses, extraction activities, specialty stone, and terrazzo-type stone to improve understanding and enforceability. The proposed rules were published in the December 28, 2018 issue of the Texas Register. The public comment period closed on January 30th, 2019, and no comments were received. Staff respectfully requests adoption of the amendments to 30 TAC Chapter 342. Staff also requests permission to make non-substantive revisions to comply with Texas Register format. Thank you, and we're available for any questions.
Thank you. Commissioner Lindley, any questions?
No questions. Thank you.
Mr. McWhorter,
OPIC supports adoption of this rulemaking as presented by the Executive Director.
thank you. I agree. I think it's pretty straightforward, non-controversial implementation of legislation, so I think we ought to move forward.
I agree. I move that we adopt the amendments of 30 Texas Administrative Code, Chapter 342, as recommended by the Executive Director.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries.
And that takes us to items 35 through 41, which are the quadrennial rule reviews for chapters 17, 18, 20, 122, 218, 298, and 305 of Title 30 Texas Administrative Code. No one has signed in to address the commission on these items, and the executive director's staff is here to present these matters.
Good morning.
Hi, good morning, Chairman Nerman, Commissioner Lindley, General Counsel, and Public Interest Counsel. For the record, my name is Patricia Drawn from the General Law Division. And with me today is Don Redmond from the Environmental Law Division, representing the Executive Director. Pending before you are items 35 through 41, the adopted rules reviews of 30 TAC Chapters 17, 18, 20, 122, 218, 298, and 305. As required by the Texas Government Code, Section 2001.039, the Executive Director's staff conducted rule reviews of these chapters to determine if the need for the rules within these chapters continue to exist. The proposed notice of the rule review of Chapters 20, 122, 218, and 305, published in the December 7, 2018 issue of the Texas Register with a 30-day comment period. The proposed notices, the rule reviews of Chapter 17, 18, and 298, were published in the December 21st, 2018 issue of the Texas Register, also with a 30-day comment period. No comments were received during the public comment period for any of these reviews. Based on the review of these chapters, the Executive Director has determined that the reasons for the rules continue to exist. Respectfully recommend approval of the adoption of the rule reviews of 30 TAC Chapters 17, 18, 20, 122, 218, 298, and 305. Additionally, staff requests authorization to make non-substantive provisions necessary to comply with Texas Register requirements. Thank you. Project managers and attorneys assigned to each of these chapters are here with us to answer any questions you may have.
Thank you. Commissioner Lindley, any questions?
No questions today. Thank you.
Mr. McWhorter?
OPIC recommends adoption of these reviews and readoption of these chapters as presented by the Executive Director.
Thank you. I agree. And I have to apologize, make a confession. I actually tuned out for a moment, so I don't, I'm embarrassed to say that, but let's just be upfront about it. Did you comment on 30 TAC Section 305.149? I'm sorry, which?
No.
Texas government?
Yeah, it said, as required by Texas Government Code Section 2001.039, Executive Director staff conducted reviews of the chapters.
Okay.
Yeah, but we reviewed the chapter of 305.
Right, but you did not comment on Section 305.149?
No.
Okay, I wasn't as tuned out as I thought I might have been, because I thought in my briefing materials that we had actually finally found a rule that, that was perhaps obsolete.
We have some coming.
Okay. Was that in?
Yeah.
So it looks like.
Chairman, if you don't mind, I'm the person who reviewed that.
Great. Yeah, please go ahead.
We will address that in a future rulemaking. I am the geek squad that found that matter. There is
Lucky you.
Yeah, in the 2003 session, 78th special session number 3, there was a budget matter that found that statute needed to be repealed. It was 361.0232B that was repealed, and that was the rule that's related to that. But we will address that in a future rulemaking.
Got it.
Unfortunately, that's my bailiwick that I find things like that. So.
Okay, that issue had been teed up in my review of the materials, and so I thought maybe you had said it and I missed it, but.
It's barely mentioned in a memo, and unfortunately during legislative session, I'm just kind of like that. So I apologize if that was confusing, but that is my Geek Squad mentality, and I apologize.
We'll take it up at a further.
At a future rulemaking, but that is not the subject of quad reviews. That's just something
Right.
that I can't help mentioning in my Geek Squad mentality.
Right. I don't know if you said your name for the record. If
Oh,
we
it's
need that.
Amy Robinson.
Okay.
I apologize.
Thank you.
Do
you have any questions?
No questions. Thank you.
Okay. So I think where we are, Commissioner Lindley, is that these rules still serve a purpose.
Yes.
And so we should go ahead with the
Adoption.
with the adoption, but acknowledging that there is this provision that the next time that the rule is opened, we'll address it.
With a fine-tooth comb.
Good. All right.
Thank you.
I think we've got it. So
okay.
I'm ready to entertain
I'm glad
a
you brought
motion.
that up. Yes. So with that, I move that we adopt the rule revisions and re-adopt the rules in 30 Texas Administrative Code chapters 17, 18, 20, 122, 218, 298, and 305 without amendment.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries. Thank you.
Items 42 through 45 are for the executive session. The commission will meet in closed session in room 4222, Building F, at in 5 minutes, as permitted by the Open Meetings Act, including Texas Government Code Sections 551.071 and 551.074, to take up and consider matters pursuant to items number 42 through 45 as posted and noticed.
The time is 10:10. We stand in recess.
Yeah.
The commission met in room 4222, Building F, for closed session from 10:19 a.m. until 11:01 a.m. on items number 42, 43, and 45, as posted in notice pursuant to Texas Government Code Section 551.074. No action was taken. The agenda stands adjourned. The time is 11:09.